And then I will hand over to David.
Okay, great. Thank you so much. Yeah, so like Rory said, my name is David Bainbridge. I'm from the States. And I'll say up front, as a disclaimer, I'm not a lawyer, but I just graduated university. But I do have, like she said, I have a number of years of experience in mock trial and moot court. It's a little different in the States, I think. So mock trial would be basically like you're presenting a trial to a jury. And it's more, mock trial is what I did that for 7 years. And then I did moot court competitively for 3 years, and then just finished in February my last year. But mock trial is more kind of it's more theater. So there is more acting in mock trial because you're presenting a trial to a jury. So you're trying to convince them, and you have witnesses and lawyers and stuff. But I mainly was a lawyer during that time as well. But I will talk about here. That being said, I want this to be interactive. So if anybody has any questions during this, please, you can either, I don't know, raise your hand, or you can just interrupt, it's fine. Or just put the question in the chat or comments or anything like that, because I'd love it to be interactive. So I'm going to go ahead and share. Here we go. So I put together this PowerPoint about, it's basically just 10 tips that I kind of thought about that I basically learned along the way of kind of presenting and preparing for a moot court competition specifically, but some of these apply just to speaking and preparing for a case generally. Sorry. So I tried to structure it as 5 preparation points.
Sorry to cut you off, guys. Please mute yourself so that we can hear David. Happy for you to unmute yourself if you are asking a question, but just to avoid a bit of disturbance, please just mute yourselves. Thank you. Go ahead.
Oh, that's fine.
Okay.
No problem. Okay, yeah. So I tried to break it up into 5 preparation points and then presentation points. And like I said, if there's any sort of any comments or any observations in the middle of it, don't worry. You can go ahead and ask, and then we can talk about it at the end as well if there are any questions. So I'll go ahead and start with the first one here. Oops. Okay. So I've said, be the subject matter expert. So this is what I was always told, especially with a moot court case, because you have a packet of, I don't know how many pages it'll be. It just depends on the competition or the scenario. But sometimes it's 50 pages, sometimes it's 100 pages, sometimes it's less, sometimes it's more. And then in at least what I was working with, you have just a list of precedent that you're supposed to know. So maybe that's like 10 different cases, or it could be much more. So the idea here is you have to know the material, because you going before the judge, hopefully the judge has read the papers, but a lot of times in moot court, at least my experience was, they have skimmed a sort of summary or a syllabus. And so they can talk about it. They know the issues, at least in moot court. But you, as the advocate or the attorney or the participant, need to know that material. I mean, it's just because you want to be able to have a conversation with the judge. And if you don't know the material, then you're not going to be able to represent your client well or compete well in the moot court scenario. So what I use a lot of times in both mock trial and moot court to do that case analysis, because it's really just, it's all case analysis to become the subject matter expert, was pro-con charts. And these can look different for everybody. But what I would do, and what my teams would do, we would go through, for example, a witness affidavit or the opinion of the lower court and say, okay, so if I'm arguing for the petitioner or the appellant, what are all the points in this affidavit or this judgment that tend to swing in my favor? And you can highlight them in the packet. You can go ahead and put them on like a Word document or something like that. And then you go through and say, what are all the harmful points? And this can be big points that are like, this would sink your case if the judge believed these things to be true, or they can be small points. But it's really helpful to go through these kinds of things. That when you get to the actual preparation of your speeches or your, maybe if you're doing mock trial, your cross-examinations, then you're going to be able to go through that affidavit and say, oh, these are the points that I want to talk about. And that can really help develop your cross chapters or things like that. Another very helpful tool in case analysis that we would always use was creating timelines. And you all may probably already know this, but timelines are so helpful, at least even just in your own mind as the advocate or the attorney, just to figure out what happened in this case. What's the story? And I'll talk a little bit more about this later, but conveying your client's story, I think is one of the most important points of moot advocacy and probably advocacy in general. But I'm not exactly sure. But I know that being able to tell that story with a coherent timeline, so you know ahead what happened when and who said what happened when. Timelines can look, there's all kinds of different formats, but really what's most helpful is just organizing the facts that you know when they happened. This can be very helpful in mock trial, but I think it also can be helpful in moot court because you need to have all the facts ordered in your head. So these are some of the case analysis tools that we used. So the second one is outline your presentation. This also may seem like a basic point, but it's something that I think for a long time I didn't do, and I think a lot of people don't do it because they're thinking, all right, outlining it's not what's going to be in my presentation at the end, so I can kind of skip that step. I think outlining is essential for both writing, legal writing, and for legal presentations, because if you don't have a coherent outline, at least in some form that you represent, it's going to be difficult to convey exactly what your points are to the judge, and especially in legal writing. If you do, I don't know if there's brief writing competitions for these different moot court competitions, but that was one aspect of ours. And if you don't outline, this is just probably in the case analysis part, if you don't outline, it's just going to be lost. And then outlining comes into play when you're actually in front of the judge as well. You want to draw from that case analysis. But when you're in front of the judge, here's the big thing that outlining does. When you're in front of the judge, if you can stick to 2 or 3 main points that are essentially the main points of your outline, and you can convey those to the judge, I think that's very helpful. Because a lot of times I've seen, so in different rounds, people will get up and say, may it please the court, I'm David representing the petitioner, and today we'll be presenting 4 different points. And I mean, I don't know what the time constraints are. There's different time constraints for every competition. But I mean, that individual almost never got through all 4 points because, maybe it's 10 minutes, maybe it's 15 minutes that you're allowed to talk. The judge is going to want to talk about 1 or 2 of those points. And then at the end, they're going to be thinking, oh, where are the last 2? So, and it's just better from a case analysis perspective and a persuasiveness perspective to be able to tell the judge, here's what I want you to rule. And we want you to do it for 2 reasons. This is the first reason, this is the second reason. Then they're able to see, okay, I can roll with that. I understand what those 2 points are. And I don't have to be thinking, oh, well, if that's true, then are these 3 other things true? So that's just a general rule that we would stick to, is just be as concise as you can with your outline. And if you have a 2 or 3 point outline, then you can really easily put your case analysis into that outline, especially if you've done the charts and the timeline. So third, so I have this is a picture here of one of the outlines that I ended up using during, well, not during competition, but this was the final form of an outline. And it's small writing here, but I'm going to zoom in on specific sections that I think were helpful. So I'm going to pull up the top sort of paragraph here. One thing I was always taught at university was the rule statement, the importance of a rule statement in mooting. And that is, it's basically the first or second sentence that you say to the judge after standing up. So you might introduce yourself. In fact, you should. My name is David Bainbridge. I represent the petitioner in this case. Once you said that, and here's an example of the case that we used this last year. Was about a polio vaccination mandate, all fictional fact. So it's, my name is David Bainbridge. I represent the petitioner. We ask this court to rule that the Commerce Clause does not give Congress the authority to mandate a polio vaccination that compels activity and is untethered from economic engagement. So what I was always told about the rule statement is that very clearly at the very start of your presentation, you're telling the judge, this is what we want this court to do. That way they don't have to be, halfway through your presentation, they're saying, okay, counsel, what do you want us to do here? You're telling them very clearly up front, this is all we want you to do. Maybe it's more groundbreaking than this rule statement. Maybe you want them to overturn some case, but you've told them up front. And maybe they'll ask you questions immediately. And that's okay. I think questions are the most fun part of it. And it gives you the chance to address what the judge wants to talk about, which I'll mention later. But I think the rule statement and rule statements are tough. It would take a long time for me to actually come to a rule statement that felt good. Even this one now, I'm thinking I could probably change this in a few ways. But because it's tough to kind of weed down, when you're dealing with all these facts, you're thinking, how am I going to just do that in a sentence or two? But that's another huge point about case analysis. If you can get your case down to 2 or 3 sentences and say it very clearly to the judge, that's going to be huge, because you can concisely do that at the end, at the start, and odds are you'll understand the case a lot better than if you have to, quote paragraphs and that kind of thing. So then the second point here, I'm just going to pull up both of these points. So kind of how I would structure the argument is start with the intro, then do the rule statement, and we ask this court to rule that for 2 different reasons, or maybe 3, but usually 2. First of all, the PVA, that stands for Polio Vaccination Act, seeks to regulate inactivity in the guise of commercial jurisdiction. And secondly, not only does the PVA seek to regulate inactivity, but it seeks to regulate what is not even economic in nature. Again, your points are going to be, every counsel's points are going to be different. The idea here is that you've stated what the rule statement is, and then you stated up front, these are my 2 points. These are the points I'm going to make. And then if the judge has already decided in their head that they already agree with the first point, the PVA seeks to regulate inactivity, maybe they just move to the second point, and that's great for you. Because, if the judge is on your side with one of the points, you just want to talk about what the judge wants to talk about. And I'll again mention that later. But this is an example of something of a structure that we'd use. And then you would just go ahead and dive into that first point. And I'll talk about, on the next slide, kind of how I would go about each of the points. So under each of the points, the structure I kind of was using towards the end, and I thought was most helpful. Everybody will probably have different preferences for this type of thing, but what I found was helpful is, okay, so you take the point, the PVA seeks to regulate inactivity. So then what is the law on that point? And I found it was very helpful to just go straight to what is the authority or the precedent on the point, and just tell that to the judge. So, the ruling case here is whatever, NFIB versus Sibelius. That was one of the main cases in that last issue. And once you tell the judge the rule and you tell them the precedent, maybe you've defined what is controlling here right now, or maybe what you think should be controlling in this case. And maybe, the judge might go back and forth with you on that. But that's fine. You want to be able to establish what the authority here is. That way the judge knows what they should be following or how they should rule. Then, once you've established the authority, you describe the facts of your case, and you basically tell your client's story. How do your facts fall in? That's what I wrote, but how do your facts sort of fit in with the precedent or the authority that you've already cited? And again, there are a lot of different ways that people will structure points. So sometimes people will start a point off by doing a quote from whatever the authority is. When using quotes, especially in moot court, I'd be very careful. If you're going to use quotes, make sure they're quick, they're short quotes at least, or you're able to, and the point is very clear. Because a lot of times people will, especially in these precedents that are written by judges, I mean, it's legal writing, so a lot of times it can be a bit clunky. Maybe it's not easily quotable. So then people will just quote or read, a whole paragraph from a prior precedent, and it's fine. But unless you have an excellent mastery of that quote, it can sound it's not great from a presentation perspective. So you want to, if you're going to use quotes, I would use shorter quotes and quotes whose point is very clear. But that's just, I mean, that is personal preference. When you have to actually read a whole paragraph of a quote from a prior decision, it can just get a little jumbled, and that can apply to presentation in general. Okay, I'm going to move to the next point. And I can't see the chat or anything. So if there are any, go ahead. If there are any questions or anything.
Sure, I'm monitoring the chat, but yeah, maybe that's a good point to stop and just allow people to give comments or questions. Does anyone have a question so far? Okay, I'm not seeing any questions yet. Please also just mute yourselves, because I could hear some people typing and stuff. So please just mute yourself so that we can hear properly. Thanks. You can go ahead, David.
Thanks. Okay, so I put use a theme here. I debated whether I'd put this in or not, because in mock trial, which I described more as a jury trial type situation, we always use themes, because the jury is supposed to be a jury, at least in the American system, is supposed to be a jury of your peers, right? And so it's not lawyers. There could be a lawyer in there, but it's usually just regular people off the street, right? So you want to kind of convey to them very clearly what your story is through a theme. And yeah, I'll just go ahead. And so a theme, it basically encapsulates your case in a short phrase, 1 to 2 sentences. I'll give you some examples, but I think it can apply to moot court and advocacy as well. It just depends, and you have to be careful, because you don't want it to sound too kitschy. I think you don't want it to sound too kind of cute, I guess, because in mock trial, you can, and just trial advocacy, you can be a little bit more theatrical with what you're trying to convey. You want to still represent your case accurately, but using a theme can kind of carry through your whole case. It can be very effective. I think the same thing can be true in moot court. It won't be as, maybe it's a couple sentences where you can state very clearly what the idea of your case is. And the idea of a theme is that it can carry through throughout the whole presentation. So that way, when the judge goes back to deliberate, they're thinking, okay, I know what the petitioner's story was, because I know what that theme was. Or I heard that phrase, a number of times. What does that mean? Oh, that's what the petitioner's story is, or the appellant. So I found these to be very effective. I was able to participate in an advocacy conference in Cape Town in July. And I found this to be so we were able to use, some of the people I was working with were able to use the theme pretty effectively in their presentations, because it kind of, instead of getting up and kind of going into the law on whatever point you're on in a jumbled way, or very quickly talking through some of your main points, you can just state very clearly in a couple sentences, okay, this is what my case is about. And once you've done that, then you've kind of set the tone, and you can go through the rest of your points. So I'll give you some examples. So themes can be metaphors, quotes, phrases. Basically, the idea here is it's something that sticks. And I'll give you a couple of examples of themes that my teams have used over the years. So man behind the curtain is, you may have seen the movie The Wizard of Oz. And basically at the end of the movie, they've come to this, the room where Oz is supposed to be. And he's saying, pay no attention to the man behind the curtain. So Oz is saying, pay no attention to the man behind the curtain, because this whole time, the man behind the curtain is Oz, and he's just standing there speaking into a microphone. So we would use stories like that. So in the opening statement, my co-counsel would get up and say, you've probably all seen this movie. Here's what happens. The reason it applies here is because what the prosecution or the state is doing is telling you to pay no attention to the man behind the curtain. Now, this, again, like you can obviously tell, is a bit more theatrical than maybe you might use in a moot court case. But the principle still applies. So then in closing argument, you could come up and say, they're telling you all these great things about the facts that they want you to see, but they're also telling you to pay no attention to the man behind the curtain. That's the alternate suspect, whoever this person is, and they're just telling you to ignore that person. And that's not what a court of justice can do. Then there's another example. You can't solve a puzzle if you throw away the pieces. So this would be, we actually use this a number of times, but the idea here is different teams would get up before a jury and tell their story, but then they ignore documents or facts that are in the case that are on record. And then you can come up and say, well, you can't actually solve the puzzle if you've thrown away some of the pieces. Here are the pieces. And they don't tell the same story that the prosecution or the defense's case has told you. So those are a couple ideas, and you obviously would want to toy around with what you use in a moot case a little bit more carefully. But I think that, and themes, by the way, are, if you don't come up with one within the first few minutes, that's okay. It takes a long time to go through these, or at least it did for some of my teams. And I was not great at coming up with themes. Okay, go ahead.
I really like this point of using themes, and I think it's applicable whether you are in moot court or just giving any other type of presentation. And I know a lot of the mentees, want public speaking and that sort of training as well. So I think, using themes is a very good way of making sure stuff sticks, as you said, because, studies have shown that humans retain stories more than facts and detail. And so if you can weave a story the way you were saying, David, where you start off with a theme and you introduce it and then tie it back to your presentation at the end so that it flows like a story, because it's easier for you to remember the story yourself, and it's also easier for the person hearing the story to remember it. So I love using themes, and I use it generally whether it's in moot court or advocacy type work, generally giving any type of presentation. I think if you can weave a story into whatever you're talking about, it's easier for you to remember. It makes for a more interesting presentation, and it's easier for the recipient to keep to understand and retain information.
Absolutely, yeah. Thank you for that. No, that's 100% true, and it's so much when I've listened to different cases. So sometimes if I got the chance to judge a trial or something, and one team, you kind of can't really tell what the theme is, or one presenter, you can't really tell what the theme is, and then the other side gets up and okay, that's what their case is about. Great. Maybe the presentations might differ, somebody might be a better presenter, but if they have a good theme and it encapsulates the case so much, it levels them up. So yeah, thank you. Okay, so, and then yes, on the point of themes and telling your story clearly, this is the fourth point, because stories are so important. Even in, you might think in moot court or like appellate advocacy, if it's just about overturning a little lower court's decision, you might think, well, the story, it's more about the law. I think it's still equally important, if not more, because you really want to convey why your client, and that's actually the point I can say here. You really want to convey why
guys,
your
please
client.
Mute yourself. Sorry, David. Please mute yourselves.
That's fine.
Okay.
Good. Okay. So yeah, you really want to convey why your client deserves relief. And that's your client's story. So that can go under your different points. So like I said earlier, you want to tell what the law is, but then you want to tell your client's story. So for example, in that earlier case, if you're the petitioner, you really want to say why this client, he's not engaged in commerce. So there's the law, and here's my client. This is an individual who lives in a rural area. He doesn't have contact with people. He's not engaged in commerce. So if you really want to show, and then if you're on the side of the government, you want to talk about why your law is fair and equitable, why it's not unfairly applying to this individual, why it's a reasonable law. So, you know, depending on the side you're on, you want to spend time talking about your facts. And that's why, you know, being the subject matter expert is so important. Because you want to be able to tell very clearly why your client is in court and why the law applies unfairly or, you know, should apply in a certain way to your client. I can't remember what oh yeah. So this is something I remember my coach in high school or matric telling me, and telling our teams all the time. Watch out for the curse of knowledge. And you may probably maybe will be familiar with this. You as the advocate or the moot court participant have spent, you know, hours and days working on your packet, your moot court packet. So you know that thing backwards and forwards, hopefully. When you get to trial or the competition and the judge asks you a question, or you're just presenting, you may make several leaps in your head from the facts. And you may get to a point very logically, and it's a great point, but the judge doesn't have the same knowledge that you do, hopefully. I mean, if the judge has read up on the facts, that's great. But a lot of times in competition, the judge will not have done that because, you know, they're a judge, they're working on other cases as well. So you want to watch out for the curse of knowledge, meaning, and this was especially true for jury trials, because you need to bring it down to the level of like your peers, right? So you need to bring it down to where you're just talking about your case. And it's very clear what your points are and what the story is. That's why the story point is so important. So basically, the curse of knowledge is just when, and again, you're familiar with it, but a jury or a judge might be thinking, "Whoa, where did they get that point from?" You may have made all of those connections logically from all the facts that you know, but you just need to make sure to, and you can kind of tell when you're presenting before a judge how much they're tracking with those points that you're making. And if they're asking lots of questions that go back to sort of the assumptions that you've made, then maybe going forward, you'll present those assumptions up front rather than, you know, just making the leaps. So yeah, I'll go ahead. Oh yes, be concise. I think this is a point that a lot of lawyers, and I mean, moot court presenters, anybody, myself included, have gotten wrong a lot. And that is, I tend to err on the side of lots of words rather than just stating my point concisely. Because, and this is true, this is especially true in legal writing, I think. A lot of times, and this is what we were told when briefs and that kind of thing, if you can state your point in just a paragraph or just a few sentences rather than, you know, several pages, a lot of times it's going to be better. Now, sometimes it's necessary, especially with, like I said, the curse of knowledge. You want to really flesh out your point. But if you can state your point very clearly in a concise or with concision, I think that's very important and very helpful. All right, so that's the 5 kind of preparation points, and maybe we can stop here just to see if we have any questions. Oh, now I can see the chat. Okay.
No questions yet.
Okay.
I think we can continue. Hopefully at the end we'll have some questions.
Okay, no, it's okay, yeah. Let's see. Okay, so this is my first presentation point. Everybody has a different presentation style, and that's great. Everybody should use their own presentation style and embrace that. One of the big things that I was told over the years, and you can kind of notice in different presentations, is that a lot of times people will, you'll have a conversation with them before the trial, and I would do this too. And then once they start presenting, it's like, we called it debater voice. So the voice is just completely different, and it's like this very precise kind of speech-giving voice. Sometimes that's called for. A lot of times, though, in moot court and mock trial and advocacy, you want to just have a conversation with the judge, because hopefully the judge is collegial and you're really just both trying to come to justice for your client and justice in general. So the more you can sort of have a conversation with them in a professional way, obviously, but have a conversation with them rather than speaking at them, right? I think that's huge. So yeah, and part of this comes with knowing your case well enough. Because a lot of times if you just have sort of a script, or having a script is okay, but having a very finely noted script and then basically just preaching it, a lot of times that's not going to land because it all sounds the same, right? And the judge is just thinking, okay, and maybe they'll just zone out. So if you're having sort of an interactive conversation with the judge, I think that's huge. Yeah, less speech giving, more conversational. And then, yeah, I said as a prep point here, this goes back to preparation. What can really help you understand, or at least helped me understand my cases all, was having conversations with my friends, or maybe a sibling or something like that. Just people around you that are not maybe lawyers, or maybe aren't working on the specific, they can be lawyers, but maybe not working on the specific case, and practice having a conversation with them about your case. Because the more you're able to just answer their questions, so you know, for example, I would have a conversation with a friend of mine and say, does this make sense? I'm just going to talk out my case with you. The more you're able to just talk out a case and then answer what a layperson's questions might be about the case, that's likely to be something that's going through the judge's head as well. So being able to just have the conversation in a simple way, not, you know, giving a speech or preaching your case, is good. Now, of course, using voice inflection and some level of passion while giving a speech is helpful, and you should do that. But the point is just basically, you want to vary that. You don't want it to all be just giving a speech. You want to kind of be trying to come to a solution with the judge. Now, of course, sometimes, hopefully this doesn't happen as much, but sometimes you will get judges who are very confrontational and are not really interested in having a collegial or a kind of a conversation, and that's okay. But you basically, the advocate, has to maintain composure and treat it the same way. So a lot of times, and in moot court, a lot of times judges will just really want to kind of go after a point really hard to see how you react and to see how you kind of stand in under pressure. And so again, yes, maintaining that composure and having a conversation.
Sorry, guys. Sorry again, David. Guys, can you just mute yourselves, please? Please, I've already asked 3 times. And the thing is, we need to make sure that there's no interference, because we're going to put the video on YouTube, right, so that other people can hear. So I would really appreciate you guys muting yourselves so that we can hear David properly. Sorry, I cut you off, David. There is a question here. So Wasani says, when a judge or presiding officer asks a lot of questions before you finish your point, and when they keep quiet through the presentation, what does it mean for you as a presenter? In other words, an interactive, somewhat interrogative judge versus a quiet, absorbing judge. What is good for an advocate? That is such a good question.
That is a good question. So I think personally, I much prefer an interactive, interrogative judge, because, and that goes to my next point, which is talk about what the judge wants to talk about. Because at the end of the day, you're trying to convince the judge, and you want to know what the judge's problem with your case is. Now, sometimes, you know, judges just, their demeanor is that they're not going to ask questions. And that's okay. That's why, and this is a great point, because that's why in your preparation, you need to be able to talk for the allotted time without having any questions, which we would call those like dry runs, or we would always have to prepare for those in practice. And, you know, that was my least favorite practice, because you're just giving a speech for 10 minutes and there's no interaction, and you really want to know what the judge is hung up on, right? And I was always told when we were doing mock trial, from like the trial lawyers that were coaching us, that when they're doing trials, they always want to know from the jury, what is your biggest problem with my case, so that I can talk about that point, right? Whereas with the judge in moot court, usually they will let you know, right? They're going to ask. It just depends, though. I mean, like, every judge is different. So I mean, like I said, I 100% prefer a judge who's interrogative, but you can't count on that. And that's why you just have to be prepared to talk for the allotted amount of time. And it doesn't necessarily, to your question, it doesn't necessarily mean anything. Sometimes judges will ask a bunch of questions of one side, a few questions of the other side, and then rule for could be either one, right? But I mean, just being able to stand up to the punches, or being able to present coherently in a kind of way that grips them, even if they're not asking questions, that can be tough. I mean, that's really tough for 10 minutes without any interaction, and you can't even tell like if their face is just blank and they're kind of just listening to it. You can't. Maybe they're zoned out completely. Maybe they're very very attentive, but it just depends. So would you like to add anything, Rory?
Yeah, so Sani says thank you. I also think, okay, obviously for moot competitions, the first time you're interacting with the judge, right, and you might not know, but once you become an advocate or you're a litigator and you consistently come before certain judges, then you will pick up certain habits, and you'll know like this judge is quiet, or like this judge will interrogate you and ask a lot of questions, and you'll be able to pick up those habits. So it's a bit difficult to discern when it's the first time you're coming before a judge, and it's probably based on their personality. And so it's just very difficult to have a concrete answer to say this is what it means, this is what it doesn't mean, because it just depends on their personality, and you won't be able to pick up those patterns if it's the first time you're coming before them.
Absolutely. Yeah, no, that's 100% true. And at one point I did not include here, but probably falls into talking about what the judge wants to talk about is, and the more mooting that you do, depending on your level of experience, reading the judge, and that's exactly what Roy said, reading the judge, kind of for how they like to deal with things. Are they very picky? Do they want you to say exactly what the page and line number of your citation is? Or are they okay if you just state this is what the precedent is, right? So, and reading your judge can apply to a lot of different things. Do they want you to answer a question in a certain structure, right? Do they want you to structure each of your points very clearly according to, but these are things that you kind of pick up on while you're presenting. And it can be, maybe you misread it, but that's fine. Yeah, so talk about what the judge wants to talk about.
Sorry, just
cater to your audience.
Go ahead. Sorry, I just thought of something just before you go ahead, David. I mean, the other stuff I think that comes into this conversation is about body language. Even though you might not know generally like what a judge is thinking if they're quiet, you can sort of pick up body language to say if you've lost the judge, are they like looking around, are they twiddling? And then, you need to try and then find a way of bringing them back. Some like common human sort of body language signifiers, do exist. And I think you need to be aware of that. Like in reading your judge, you need to be able to see, you'll be able to pick up whether sometimes, whether, you've got their attention, they are following, they're understanding. But if they're sort of squinting or like moving up their eyes when you're talking, you can see that you've lost them. So also take that into account and not so much stick to, I think, where your presentation is going. Also be able to have the flexibility to, bring your judge back if you see that you've lost them. And obviously that comes with the preparation, talking to them like you're having a conversation, not talking at them and all of that. So I think it's important to highlight that.
No, absolutely. Yeah, thank you. Yeah, body language is huge. And you do want to, that's another thing you're trying to read. And yeah, if somebody clearly looks like they're kind of falling asleep or zoning out, you want to somehow bring them back. That can be through a number of things. Maybe you could say what the judge or what the court, or what we present that the court must decide or must pay attention to specifically in this case is this. And maybe then they're like, oh, okay, maybe I should be paying attention now. It just depends. Oh yeah, so this is the same point about basically the jury. You want to know what, because you've prepared and you spent hours and all this time preparing your case, you have your outline, and this would happen to me a lot of times. So I would, say what my outline was, and then the judge would basically immediately say, all right, I don't care about your first point, I want to talk about your second point. And as a presenter, you're thinking, that's like 4 minutes of my presentation, I need to talk about that, the first point. But at the end of the day, you want to be prepared to the point that it doesn't matter what you end up actually talking about during the presentation from a knowledge perspective. All you want to get out of that round is talking about what those judges want to hear, right? It can be different in, I mean, I imagine it could be different in actual trial advocacy because you need to have certain things on the record, but especially with moot court, if a judge is hung up on one aspect of your case, you want to talk about that aspect, right? Because you know, if you agree on the other point, then there's no use spending 3 minutes on it. And maybe the second point is a harder point and the judge wants to know how you stand up under fire. So, and I think the next point is be flexible, because you want to be able to go into a trial and talk about whatever needs to be talked about in that trial. And this is going to vary. I mean, we would do, you know, 4 or 5 different moot competitions in a day, and you would talk about something different in every single trial. And that's why the preparation is really key, because you need to be able to be so flexible with jumping around too. And that's actually, I didn't include this point, but transitions between points are huge, and they make it seem like you are in complete control. Actually, this is a good point. Transitions that I should have included, because if you are able to basically make it seem like you are basically flowing through your own argument while taking their questions, and that looks so good. So if you have a question and you're still on your first point, but you're kind of wrapping it up, and you can sort of say, yes, Your Honor, or yes, my Lord, or my Lady, you know, say whatever your answer is, and that leads me directly to my second point, and that leads me to directly to something under my second point, because then you're showing the judge that you're listening to their question, you're understanding their question, and you're using your own outline still, and your outline is still good, it's still applicable. And then the judge is thinking, oh wow, this person really knows what they're talking about, and they know they've prepared to the point where they can take my questions and weave them into their own structure. So being able to kind of say, do the kind of transition. Your question leads to my next point, or that's something that's addressed under this precedent, which falls under my second point, or something like that. And this is one thing that probably goes to that same aspect of the judge being hung up on. I've heard a lot of times participants or competitors will get a question from the judge, and it's early on or something, and the question applies to their third point, and they say, well, Your Honor, that question goes to my third point, so I'll address that later. I don't think that's a good strategy, because the judge is asking you about it because he wants to talk about it now, or she wants to talk about it now, right? She doesn't want to talk about it later. So just go ahead and address the point and say, and if you've felt like you've talked enough on your first point, then you're good. If you need to wrap it up and say, and just closing out that first point, you know, ... So yeah, that's good.
Sandy was going to ask you exactly that, and he's like, okay, you just answered my question. He was asking about, do you leave the point to be discussed for later on if a judge asks you and you haven't gotten there? So
oh yeah,
you've just answered his question. I think that's such
okay.
a good point, and again goes back to storytelling. You just need flow. Like your presentation, it's like playing music, right? It just needs to flow. You need to be able, as you said, to weave in like your different points, keeping your structure intact, but having the flexibility to accommodate the judge's questions and just keep the flow. So it's a really good point.
Yeah, and that's a great question too, because it will depend. I mean, if you feel like you haven't said what you need to say to wrap up that first point, then say. And before I sort of continue on, I just want to mention this, but I would answer the judge's question first about the third point or whatever. But yeah, that's a great question. Oh, okay. So be honest about your case. Now, this might seem obvious. You should be honest with the judge, but the point here is a lot of times people are worried about being competitors are so worried about being wrong that they can overstate, and you overstate to the point where you don't have any justification for what you're overstating. It is much better to be able to tell the judge what the limits of your case are, because your case is not the perfect case, especially in moot court. It never is. I mean, you can't even really know which side is right because they're trying to balance the case. I think in seeing different people compete, the people who will acknowledge, yes, Your Honor, yes, my Lord, our case only goes this far. And there are problems if the court attempted to extend this. There are problems if, these facts were present here. But what I can tell the court is that in this case, my client, acted in this way and the law applies to him in a specific way. But it is okay to be able to say there are problems with the case. And in fact, if you can, talking, and this is generally a point about argument, presentation, advocacy. If you can take your worst point and be able to talk about that the whole time in a way that makes, in a way that's convincing, you should win the case, right? You should always be able to go, what's my worst point? What's the most damning evidence against me? And say, how can I make that work in my favor? Because that's what the opposing counsel is going to talk about, right? They're going to talk about your worst point. So if you can take your worst point and really just show those to the judge and say, one of the problems here is this, but we present to the court that, here's the answer. And it'll take time coming up with the right answer, but that's time very well spent. This is one of the biggest things that I've seen a lot of times, and the judge will ask a question to an advocate and you might not know the answer. That's okay. This applies to a lot of things as well. Not knowing the answer doesn't mean that you lose. But if you use it in a way that, if you basically say, if you pick an answer, so if there's a hypothetical and you just pick yes or no, but you have no idea, that could get you in this big rabbit hole and your case is going to be in trouble because you're going to be, hemorrhaging the whole time. And you're going to be trying to, bail yourself out because the judge has caught you in sort of like a trap. Because a lot of times they're trying to see if you'll bite, right? With hypotheticals. So a lot of times it is better if you don't know the answer, just say, Your Honor, I don't know necessarily the answer to that hypothetical. What I can tell you is, in this case, the facts of my client's, record, the facts of the record here indicate that my client falls squarely within the law or whatever. But if you say, I don't know, I think it's great to always sort of pull it back to what you do know, right? That way it doesn't seem like, and obviously you don't want to be saying, oh, I don't know, I don't know, I don't know. You want to be prepared. But judges are going to ask tricky questions. I mean, they're jurists who have been doing their job for longer than you have, right? So it's good to just be honest. And a lot of times people will overlook it and then they'll get in trouble, right? Not like trouble with getting down these rabbit holes, and it's tough. Let's see here. Oh yeah, and be a real person. I mean, this kind of falls under a lot of different points, but we would always say this about witnesses when you're trying to prep witnesses for trial. You want to come off as a real person. And same thing for the advocates. This is probably the same point I was making earlier about not giving a speech, but having a conversation. You want to be real. You are an imperfect person and you're just giving your client's argument, but there are limitations to that. And you're not a perfect advocate, and nobody is. So as long as you can, it's fine to convey that to the judge, because the judge knows the judge isn't perfect either. But overstating and sort of trying to make it sound like your case is the only way that the judge could possibly rule, it just kind of makes the judge not really believe your case, or, so yeah, that's what I have about being honest. The next point is be confident. This is just a general point, and being confident can be difficult, but I think I would hear so many times throughout both mock trial and moot court, at the end of the round, the judge would say something like, or the lawyer, the judges or the coaches would say something like, you had a great argument, but it didn't sound like it was a great argument, right? Because you weren't presenting it like it was correct. So you really have to believe in your case, even if, like, some of these fictional cases, I don't necessarily believe in what I'm arguing as a point of law, because they're fictional cases, right? But you have to, especially with moot court, you have to be able to present that in a way that's convincing and and it conveys that you believe that point, which again can be tough. But I've always heard, fake it till you make it, whatever you can do to kind of get to the point where you're presenting your client's facts in a way that sounds convincing, even if you aren't necessarily convinced. Because like I said earlier, with moot court, it's unlikely that you're going to be fully convinced from a legal standpoint of either side. And maybe that's probably true of being a lawyer and advocacy generally, because it's people are imperfect and your case is going to be imperfect. But that's just part of presenting it well. And that's a very general point. And then my final point here is something that I probably neglected even today, and that is slow down. So the reason I include this is that this is what my coach would tell me before, and again, very general point, but my coaches would tell me before every trial, and that is slow down. Because even, everybody going into trial is hyped up on all this different energy, and you're nervous, you are trying to say the right thing, and then you're just flying through your points, and the judge is thinking, this is just so much information. And even if you're presenting confidently, presenting very well, you don't have time for intonation. You don't have time to vary your tone or the different things, presentation aspects that you want to be good on, because you're just spouting words and you're just flying through your outline. So slowing down is something I'm still working on, but it's so huge for presentation generally, because it's not usually, you don't usually have to worry about fitting all of your points in. And even if time is a concern, even if you're working with 10 minutes or something for your presentation, it's better to cut your presentation down to just 2 points and talk slowly through those points, because it's just, from a presentation standpoint, it's just so much better than talking quickly, and it helps. And then once you learn how to talk slowly through your facts and your evidence, you can work on specific aspects of the presentation, like varying your tone. Which points here do I need to really hone in on? So that's what I have on for the 10 points. I think, what time are we at? Oh, it's 5 till. So yeah, would you like to add anything, Rory, or are there any questions?
Yeah, so I think definitely, I think the slowing down is so important. And this is also something that I have to work on. And I remember when I did Toastmasters in university, this was a big thing for me. Like when you're presenting or when you're talking, your tone and the pace of talking is going to be slower than if you're having a one-on-one conversation. So in as much as, yes, you need to have a conversation with the judge, you need to realize that you are presenting, and your pace then needs to be slower than if you are like having a one-on-one conversation. And that also helps with your breathing. So I know I talk too fast, and then what happens is when I'm talking, I end up not being able to catch my breath. So I don't know whether you guys have picked up on that, but a lot of my presentations, and I'll hear the recording and I'll talk, and then I'll go, then I'll talk because I'm not breathing, right? So I'm not going, and that's like a pet peeve for me, right? And slowing down also helps you stop with the non-words, right? So the and the like you can fake confidence by just pausing. Being quiet in between your next point actually projects confidence, even though you don't feel like you're confident before. So the most effective way to actually fake confidence is to slow down your pace. And it also gives you time to breathe, calm down, and be able to then say your next point properly. But I think slowing down is such a big trick, and it helped a lot, because I think I was really, really bad before I did Toastmasters, and it has improved greatly. And if you just keep that, if you hear nothing else from this conversation, like literally just slowing down the pace of your talk projects fake confidence if you don't have it, but it also gives you time to actually articulate yourself properly and gives you time to gather your thoughts.
Yeah. No, that's very true. And I would add, using pauses actually can be it can be very effective. Even if, like an example, even if you're going between your points, and you need to take a pause to gather your thoughts, that's great. But if you can also, and you should do that. But also if you're making a big point, like basically the point that should win you the case, or whatever you think is the most important point, say the point and then pause, because it lets it set in, And silence and pauses can be so effective, because then the judge is thinking, okay, that's actually a really good point. I should be thinking about that. And then you move on to your justification or whatever's next. So yeah, that's a great point.
And the other thing about pauses as well is if you're losing your judge, because silence is uncomfortable for everyone, right? So that's why people, as a presenter, you don't do it. So the minute there's silence, because people will be like, if you've lost them, right, and you're going on with your presentation and their mind is wandering, it will be like that, okay, she's talking. Then if all of a sudden there's silence, like it will bring them back to attention to be like, there was this, hum, talking, then there's silence. So it also brings back the attention of the people you're presenting to, because they'll be like, firstly, why is the silence? And then they'll wait for you to then say something else, because silence is uncomfortable for people. So yeah, I think it's a very good strategy to use, and pauses used effectively can be very powerful for any presentation.
Stop sharing.
Okay, let's see. What am I doing?
Questions?
Are there any questions?
Yeah. Good morning, everyone, and thanks, Rorisang, for this a kind of initiative to just help us, get to be mentored and to know and understand where we're going. And thanks to David for the presentation. So my question, maybe it's a generic question, and it's also a very personal question, like which kind of presentation style or advocacy style works best? Is it brazen and confident and sounding a bit like you know it all, or is it more professional, more relaxed, or is more emotionally detached and you like presenting as if you're another person, you're not including yourself in there? What kind of style? Maybe you can also just give us your own experiences as a muter. What kind of style worked for you? And obviously people do differ. They would present as per according to how they feel comfortable.
Yeah, that's a great question, because it does differ for everybody. And I don't think there's necessarily one, this is the ideal style, or there are some ideal styles of presentation, but there's not one that basically all others are wrong, because you, like I said, I think earlier, you want to embrace what is your presentation style, right? How do you communicate with people best? And you want that to carry through. Personally, my experience has been that I've tried to stay away from being more like brazenly, sort of confidently presenting. It's great to be confident, but you don't want to be sort of like this, you're preaching at the ditch, right? Especially in moot court. That's why I said earlier, I think my personal preference is having a more conversational and yet professional and very competent style. You're just there to have a conversation with the judge. You know the facts very well, but you're able to have that conversation in a professional way, and one where you're not shouting at the judge. Essentially, you must, decide the case in this way. You're not really, it's not all at one, like the tone is not all the same. You're varying your tone, and you're kind of impressing on the judge what is important about your case in a way that's, it's, and the point about detached, like being emotionally detached, you don't want to be completely emotionally detached in moot court, even though I think moot court and appellate advocacy is definitely less emotional and dramatic than something like mock trial. You still want to be able to say, this is why my client should have justice in this case, or my client deserves justice. This is why, this is the outcome that he should, or he or she should receive in this case. And you want to be passionate about that, but you don't want to be, passionate the whole time, right? Because then there's no variance and they don't really know what's important. Hopefully that's helpful. Would you like to add something, Rorisang?
Yes, I would like to add something. A little person knocking on my door. I think your style depends on who you are. So putting on a persona will just trip you up, right? Because it's not you 100% and you won't consistently maintain the persona. So I think you need to know what your personality is and stick to your personality. I don't think shouting or, being very brazen and like outwardly confident, waving your arms and like projecting this big voice won't change the facts and won't change the law. So whether you say it in like a brazen voice using a lot of hand gestures or whether you're having a conversation, the law is the law. So the style won't necessarily change the outcome of your argument. Obviously, you need to be confident in giving it. And I 100% agree with David. I think having a conversation shows a lot more confidence, right? And you're less likely to trip yourself up. And I always use the example of Utulima Donzela, right? Who is a very quiet, and for David who doesn't know, she used to be our public protector, like I think it's the equivalent. No, it's not like the Attorney General in South Africa, but she's head of like a regulatory body in South Africa, the NPA, which is like more or less like the Attorney General, and she was the public protector like 3 years ago. Very quiet lady, like speaks with a quiet voice, very well respected within the legal community in South Africa, and she's a perfect example of quiet confidence, right? She never shouts, but she's very confident in what she says and she'll get her point across. So you can be confident, you can be an authority without necessarily shouting. There's different types of speaking sort of styles and skills, and don't shy away from, if you're a quiet person and you just want to have a conversation, that's fine. It doesn't mean that you'll be a less effective advocate or litigator. It just depends on your style, and you need to, I think you're less likely to trip yourself up if you maintain the conversation style and, just stick to the facts and the law.
Yeah.
Right. Yeah. Thanks a lot for that. Yeah, it really helps because you don't have to put on a persona of some sort. You become yourself and you argue the facts and the law. Yeah, thanks.
I think you're muted. Yeah, sorry.
The whole conversation by myself. I asked whether additional questions, and I don't think there are. This was fantastic. Thank you so much, David. I think we all learned so much. I will, as I said, be putting it up on YouTube for people to just revisit and look at it. And I think I get a lot of questions. Oh, Buntle's got a question. Hi, Buntle.
Hello, I don't have a question per se. I just have a comment. I'm actually a practicing attorney, so I don't do moot courts at the moment. However, I am going to my first High Court appearance next week. Okay, in a moot setting, like not moot, in a
Trial advocacy.
what is this called? No, not trial. The other
Oh.
one now. Application.
Okay.
Yes. Application, right? So High Court, I've been doing magistrate court and the lower courts, I've been doing that. So I found that in the Higher Court, it's a different way to speak to the judge as opposed to the magistrate, because with the magistrate, you are teaching the magistrates as much as they're teaching you. And the High Court, the judges actually know what they're talking about. So I really want to thank the session, that it really helped me to put my thoughts together for next week. Yeah, that's all.
That's fantastic. I'm so happy that it's got immediate results and it's relevant to something you're going to be doing next week. Rose has her hand up.
Good afternoon. So my name is Rose. I'm from Kenya, and I just got admitted last month. But mine is just an appreciation for this presentation, because I have not yet appeared in any court, but in a month's time, I think I'll be appearing for the first time. So thank you so much, David, for what you just taught us. I believe I'm going to put what you've told us to practice, and yeah, especially the nervousness. I don't know how I'm going to work on that, but yeah, I'll try to have a conversation with the judges and the magistrates. And yeah, I really will build my confidence with that. So thank you.
Thank you. I'm so happy to hear that. Hopefully this stuff will be helpful. Yeah, and confidence, I mean, I think it's tough because I still get nervous, you know, when speaking and everything like that. So it can just be tough, but the more you just make yourself do it, it's such a useful being able to speak, right? And then, yeah, talking it through, just having a conversation, you know, with people around you can be very helpful for preparing for that. So yeah, good luck. I'm sure you'll do great.
Yeah, thank you.
Yeah, all the best, Rose. And with confidence, right? Like we all get nervous. I get nervous a lot when I'm about to speak. I mean, I even get nervous like going onto these Zoom calls like every Saturday, you know. So I think great speakers, it's not that you might not get ever to a point where you don't get nervous, right? But you then train yourself to calm down your nerves. And I think the practicing helps a lot. So talking your presentation through, because if you don't practice, then you know you won't be able to deal with your nerves for the first time before the judge, right? So if you have a conversation, and I think the other tip of having a conversation also calms down your nerves, right? Because it then makes it less scary because you have conversations all the time. And practicing and practicing and practicing like a million times, you know, before you go before the judge really, really helps you, and it makes, you know, your presentation seamless. I always say, like, you know, if you watch documentaries about Beyonce, right? Like Beyonce is like the biggest star in the world, but like she will practice like 6 months in advance, and she will like literally down to the T for her performance. And then when she does this, it's seamless. Like everything that is amazing or anything that, you know, is worthwhile doing, you actually need to put in the work and practice. Like no one goes out onto the field, even like mega superstars, basketball players, soccer players, they practice, right? So the magic that you see on the field for the 90 minutes of play is backed by hours and hours and hours of reps and gym and practicing. So, and it's the same thing with child advocacy or mooting, like you need to practice. And once you know your story in and out, once you know the law in and out, once you have the outline that David spoke about, then, you know, that's like 90% of the work done. And you will see that if you do the prep, if you do your outline, if you know your law, once you open your mouth, it will flow. It will flow, and it will really, really help with your confidence. I think your confidence gets knocked and you are not as confident in presenting if you don't know your law and if you don't know your case and if you haven't practiced. So I think there's a lot of good ways to get around the confidence issue, and preparation and practice is key.
Thank you.
Sure.
And if anybody, go ahead.
No, go ahead, David.
I was just gonna say, if anybody wants to reach out or anything, I think, so maybe what's the best way? Maybe you could share my contact information with one of those emails or something. And then also you can reach out over LinkedIn as well with the post recently. But yeah, I mean, send me an email.
Of course. Do you mind sharing your slides with me? Because we literally have like 250 people on the group, and we'll usually have like about 20 or 25 people joining on the Saturday, and I think everyone just is busy on the day. So I think I will, but people, I do usually get a lot of queries afterwards on the presentation and then the video. That's why I set up the YouTube channel. So I will put it up on YouTube. I will put your details up, and I will share your slides with everyone else.
Great.
But this was fantastic, and it was so informative, and I really, really appreciate your time, David. It was very insightful.
Absolutely. Thank you so much. Yeah.
Sure. Thank you, everyone. I will see you in October. Yeah? Okay. Bye.
Okay. Thank you, everyone. Thanks. Bye.
Bye.
Thank you. Bye.